Hello guys, welcome back to our last video in our drafting class on deed of assignment. In our previous video, we learned how to draft the introductory part, the operative part, and the miscellaneous part of a deed of assignment. So, in this final video, we'll be learning how to draft the concluding part of a deed of assignment. But before we jump in, guys, please and please, if you are yet to subscribe to this channel, please do so and share this video with your colleagues who might need it. So, what are the clauses in the concluding part of a deed of assignment? So the following are the clauses included in the concluding part of the deed of assignment. We have the testimonium, schedule, execution clause, attestation clause, and franking. So we're going to go again so you are able to memorize these clauses. One, we have what? The testimonium, schedule, execution clause, attestation clause, and franking. So now that we have been able to list them, we're going to look at their functions and then how to draft them. Of course, we're still using a scenario. So let's start with the testimonium. So what is the function of the testimonium in the concluding part of a deed of assignment? The testimonium is that clause that introduces the concluding part of a deed of assignment. You'll recall that testatum introduces the operative part. So just like the testatum introduces the operative part, what the testimonium does is to introduce the concluding part of a deed and bringing it home, deed of assignment. So let's look at how to draft the testimonium. So in drafting the testimonium, you have to write it this way: in witness of which the parties have executed this deed in the manner below, the day and year first above written. We're going to take it again. In witness of which the parties have executed this deed in the manner below, the day and year first above written. And you have to memorize this format because this style of drafting the testimonium is not only limited to drafting the deed of assignment. When you are confronted with a question asking you to draft the concluding part of other examples of deed like lease, deed of legal mortgage, deed of sublease, you have to draft the testimonium this way: in witness of which the parties. Don't forget that a deed of assignment is an indenture, right? So in which the parties have executed this deed in the manner below, the day and year first above written. When you look at this draft closely, it hints you that you are about to see the execution and the manner of signing by the what? Parties. Of course, the phrase first above written is referring to the date specifically contained in the commencement clause. That is the date that the transaction was written. That is, this document was written by the parties. When you said this is your assignment made this dash day of dash, when you fill that date, that is the date you are referring to below the day and year first above written. So that first above written is referring to the date in the commencement clause. Now, I only said that so that it helps you to memorize it. That okay, this is the clause that introduces the concluding part. This is the clause that hints me that parties are about to sign. This is the clause that relates to the commencement clause. So this understanding will help you in memorizing this draft. So what is the function of the testimonium once again? The function of the testimonium is to introduce the concluding part of a deed. So let's move to the next clause, which is the schedule. So the next clause is the schedule, right? And you are very familiar with this. Now, as we go on in the course of our explanation, you realize that this is not the first time you are hearing that word schedule. Now, what is the function of schedule in a deed of assignment and in any other example of deed where it appears? The function of a deed is that it is used to keep the deed tidy such that it makes it readable and the deed is able to have you're able to maintain your flow of thoughts. Now, let's use the 1999 Constitution, right, of Federal Republic of Nigeria, for example, because there are a lot of schedules referred to at the back of the document. You realize that if you go to section 3 of the 1999 Constitution, what it does is that section 3 defines the state of the federation. When you check subsection 1, it lists all the 36 states. You know state and capital now, right? So you are going to do that yourself. You know all the states in Nigeria. So when you check section 3, subsection 2, what it does now is that it refers you to the first and second column of part 1 of the first schedule that defines the exact geographical area of those states. When you check subsection 3, what it does is to refer to the third column of that same schedule to define the capitals of those states. Now, what are we saying? Instead of the draftsman, after writing the 36 states, they now start listing all the the capitals of the state and also the geographical dimension of the state. What they do is to banish those facts to the schedule. So what it does is that it helps you to read it easily, and then you maintain a coordinated flow of thoughts. So for example, the schedule in the deed of assignment is used to keep the deed tidy because it contains details of the survey plan, graphs, site layout, property pictures. So imagine you are drafting your operative part, and then after getting to the parcel clause, after you have already said all that, land situated at number this, after writing the parcel clause, you now start including, if there are pictures concerning the land, you're including the pictures, you're including the survey plan, you're including the. Now, it's not as if that will not be tenable, but for the sake of readability, it becomes confusing, right? It won't help the easy flow when you are reading and drafting the operative part. So, which is why there are things you need to now banish to the schedule. So, this schedule helps your draft to be what? Tidy. Because now, since there is a provision for the schedule, now you can have more than one schedule. You can have first schedule, second schedule, third schedule, based on what the draft dictates or the transaction, right? You are able to put those things there such that if after referring to the parcel clause, I need to know the exact dimension of the land, I can just go to the schedule, which is found in the concluding part of the document, and then check the survey plan. I can check pictures. So you see that it keeps the deed what? Tidy. Please note this. It is not compulsory or mandatory that a deed of assignment must contain a schedule. And here is where I need to also make another statement. If the question in your bar finals is requesting that you list out the clauses in a deed of assignment, I have not in any way said that you should not mention the schedule. You have to list it. But what we are saying is that if the question now goes ahead to say, draft the concluding part of the final document, omitting the draft of the schedule is not going to be injurious to your mark. It's not going to do any harm, right? Because it is not a mandatory feature that must be present when drafting the deed of assignment. Why? What if the land has not been surveyed? What if there are no site layouts? What if there are no pictures, right? Would you be asked to draw pictures in the bar finals? So you can see that it is not a mandatory feature. But what if you are now asked to draft the schedule? Of course, that is why you are watching this video. I'm going to show you how to draft the schedule. And like I've said, you can have more than one schedule, right? Depending on the nature of the transaction. Also, one of the functions of the schedule, you can write this down, is that it can serve as an interpretative guide for the court. For example, we just mentioned that you can include the survey plan and the site layout of the land, the parcel of the parcel that is the subject matter of the sale. You can include it in the schedule. So if, for example, the dimension of the land, the boundaries, becomes an issue, especially under the parcel clause, the schedule now may become the last resort the court will look at to resolve the ambiguity. Now let me take you back to the parcel clause that we drafted earlier. Now, we said all that parcel of land lying and situated at number 5 Niger Street, Uze Zone 5, covered by certificate of occupancy number 49/59/2018A, and more rightly described in the survey plan to be prepared by a licensed surveyor attached to the schedule with all rights, easement, and appurtenance. Can you see that what we have done here is to say that, see, this parcel of land is lying at number 5 Niger Street, Uze Zone, and is covered by certificate of occupancy. If for any reason we now need to be sure as to the exact measurement of the land, parties have agreed that the exact measurement of the land is as contained in the survey plan that is found where in the schedule. So if for any reason there's a dispute as to the dimension of the land, where do you think the court will look at in order to resolve that ambiguity? It will then go to the schedule to see how the schedule has what described the land. So let's go back to the schedule clause. So you can see that the aim, it keeps it tidy, it is not mandatory, and also it is not statutorily compulsory, and it also serves as as an instrument that can help the court to arrive and clear any ambiguity that may arise in the course of litigation. Now, another function of the schedule, which we already discussed when we're talking about the things that must be found in the formal contract of sale of land, is that the schedule can also be used to legitimately minimize stamp duty by separating fittings and features from the consideration paid for the land. So I want you to notice that phrase, legitimately minimize. So we are not in any way teaching you to evade payment of stamp duty, right? What we are saying is that one of the functions of the schedule is that it can also be a way you as a legal practitioner can minimize legitimately the amount to be paid as stamp duty in relation to that land. Now, that brings us in talking about so many things, because now we have to say that Chief Adiola, working with our scenario, Chief Adiola is to purchase that plot of land, that piece of property from Jumoke Kende. Now, what we are saying is this: there is such a thing known as fixtures and fittings that are found on the bare ground. So we have three things: one, the bare land; two, fittings; we also have fixtures. Bare ground in the sense that, what if there was no development on the land? So you don't have any building on the land, you don't have anything on the land, then you have the bare ground alone. Then when you now start having fixtures, what do you mean by fixtures? These are items that are permanently affixed on the land, such as, let's say that house now, house, borehole, overhead tanks, right? Machines. Those are fixtures, because they have been permanently affixed to the land. We also have another category of property which is known as fittings. Now, these fittings are like chattels, right? Things that are detachable. They are not permanently attached to the property. For example, there's a generator, refrigerator, right? Television sets, such that you can easily just unplug them and remove them from the item, and then you would not say that you have damaged any structure of the house. So now we have the bare ground, we have fittings on the land, we also have fixtures. What we are now saying is this: the question is, what if there was no fitting? What if there was no fixture? The bare ground still has value. The bare ground itself, without those fittings and features, has is also valuable. So now, if we go back to our scenario says that Chief Adiola is paying 400 million naira for the property. But what if without the buildings, the fixtures and the fittings on the property, the land is only worth 100 million? What are we going to do? Mr. Chief Adiola is still going to be paying 400 million naira. But this time around, we have been able to distinguish the price of the bare ground as distinguish it from the fittings and fixtures on that what property. So what are we going to do? We are not going to ask Chief Adeola to just pay 100 million naira. Chief Adeola is still going to pay 400 million naira. But what we are going to do is very simple. We are going to move all those fittings and features, itemize them in a tabular form in the schedule, calculate it, and then everything, let's say for the purpose of our example, would be 300 million naira. So what we are going to do is to therefore in our consideration clause mention that in consideration of the sum of 100 million naira paid by the assignee to the assignor, the receipt of which the assignee what acknowledges. The assignor what acknowledges. Now, having said that the assignee paid 100 million, in the schedule, we will also list out the fittings and features, calculate it to be what 300 what million. So at the end of the day, Jumoke Kehinde is getting what 400 million, but we have separated the value of the bare ground, distinguished it from the amount paid for what fittings and features. So what will happen is this: when you as the legal practitioner takes that deed of assignment for perfection and then you want to pay stamp duty, you will only pay stamp duty based on the value of what 100 million. You will not pay stamp duty for the value of 400 million. Why? You have moved the fittings, the amount of the fittings and features to the what? To the schedule. What the tax master is concerned with is the amount stated in the consideration. So this is one way. What have you done now? You have legitimately minimized the stamp duty by separating the fittings and features from the consideration paid for what? The bare ground itself. So let's go to the draft now. How then do we draft the schedule? Don't forget that we can have more than one schedule. We can have first schedule, second schedule, third schedule, right? Depending on whatever we want to put in each of the schedules. So let's look at how to draft what we have. So we have the testimonium already. The manner below, the day and year first above written. So now, then you head it as schedule, and then you start by saying all that parcel of land lying and situate at number 5 Niger Street, Wuse Zone 5, Abuja, Nigeria, the same measuring approximately 2,550.817 square meters, particularly described and edged red on survey plan OD/1785/2018/085, dated the 2nd of October 2018 and delineated by survey pillar number CSC/ODAJ 6537 AB and then SC/ODAJ 6538 AB. Then you have comma SC/ODAK 8408 AB and SC/ODAK. Now it just depends on, now this is just fictitious, right? On the said survey plan prepared by Surveyor BC Adejoye, a licensed surveyor of number 8 Italina Street, Ajoro Street area, Akure, Ondo State. So what you have here now, what is it doing? It's giving you the dimension of the land, right? Tells you the site layout, right? So what we have done now is that if for any reason there's an issue with the parcel clause as to dimension, we come to the schedule to rectify that. It has served as an interpretation guide to the court to properly interpret the dimension and measurement of the land. What about the issue of the fitting and features that we mentioned? Now let's look at this example. So this example again is what? Fictitious, right? So you have your second schedule, which is a list of the fittings and features found on the land. So these are just illustrative what? Prices. So let's say for example, the examiner is even benevolent with you. In the scenario, he has mentioned some things on the land. He has mentioned that there's a refrigerator, there's a TV set and all of that. And then he tells you to go ahead and draft the schedule. You should be very happy because it's just a very simple, we just write schedule. right? You underline it, and then you rule your table. You describe it, the quantity, the price, and you are done. That's the schedule. You have to be very confident because this is actually how to draft your schedule, especially when what you want to do is to list out the fittings and the what and the fixtures, right? So you may be told to draft the testimonium and then the schedule. So this is exactly how to draft it. So you can see that schedule is not what mandatory. It depends, which is why we have said that if you are not asked to draft in the exam, you don't have to go the extra mile. If your scenario has nothing to do with fittings and features, you can't start improvising and all of that. But who knows? It has never happened before, but who knows, right? Then you already know what to do. So moving on to the next clause, which is the what? Execution clause. The execution clause. Now, I'm very sure that we have dealt with this like exhaustively in the main tutorial video when we're talking about a deed has to be signed, sealed, and delivered in relation to the function of signature on this deed of assignment. But one thing is clear about the execution clause. It is that this is the clause where the parties seek to bind themselves to the content of the deed in context to the deed of assignment. First of all, by the parties, that is the assignor, assignee, appending their signature to this document. Don't forget testimonium. Testimonium said, in witness of which the parties have executed, right? So it is in this execution clause they will now what execute. In executing, by executing that document, you are saying that one, there exists a transaction between you and the other party. Two, this document is a true reflection of what has transpired and was agreed upon. Three, that you have read this deed of assignment and you understand the legal implication of the document as it affects your rights. In this context, the assignor knows that what he is doing is that he is divesting himself of the legal estate in his land. When the assignee is also appending his signature, he knows the legal implication that he becomes the new owner of what? The parcel of land. So, bringing it home to our scenario, Chief Adiola knows the implication of appending his signature. Jumoke Kende knows the implication of appending his signature. Once Jumoke Kende has signed, she knows that she no longer can tell another person that that land still belongs to me. No, it does not belong to you. You have signed, knowing the legal implication that the moment you append your signature to this deed of assignment, you have agreed that all your unexpired residue in respect of that land has now been passed to Chief Adiola. So this is where parties seek to what? Bind themselves to the content of the deed. Also, in drafting the execution clause, you must note the legal status of the various parties in the deed of assignment, because each of these parties, they have their different formats to draft their execution clause. And this takes me back to what we discussed when talking about parties. You remember that I told you that you have to be able to identify the parties in the scenario, because an individual can be the assignor assignee. Couple, to show joint ownership, can be assignor assignee. And a donee may be acting on behalf of a company. A donee may be acting on behalf of another individual. A donee may be acting on behalf of a family. You can also have an incorporated trustee. You can also have a company. Now, what I'm saying is there are different ways of drafting the execution clause for each of these various parties. So it's not just for you to say, oh, I know the execution clause. The first thing is, have you been able to identify the parties? When you look at our workings, the scenario we have been working with, Chief Adiola and Jumoke Kende, the names are names of what? Natural persons. So when drafting the execution must reflect the legal status of the parties. How do you draft for private individuals? That's what we're going to see as we proceed. But you must note that the way to draft it for a company is not the same way to draft it for an incorporated trustee. There's what to include. It's not the same way you will draft it if a donee is selling on behalf of, let's say for example, Jumoke Kende appointed ABC as donee to sell that land on her behalf to Chief Adiola. How we will draft and couch the execution clause will be different. So these are the things you need to know. So that tells you that the examiner can ask you, he can decide to be benevolent and say, you know what, in this exam, We're going to be giving people to draft the concluding part, but the scenario will be giving you different people of different legal status. Maybe question 1 is a company and a school which is an incorporated trustee, right? Then they ask you draft the concluding part of the final document. You say, this question is simple. Don't just go and draft for. Don't make the mistake of just rushing. Identify the parties first. Who are the parties here? Then you can know, okay, this is a company, this is an incorporated trustee. This is how we draft it. Now, another important point to note is there are persons of authority. I call them appropriate persons of authority to append their signature to the transaction. For example, if you can note this down, if the family is transacting as assignor, assignee, it is expected that you have at least 3 signatures. Why? You need the signature of the family head and principal members. You can't run away from it. So there are appropriate persons of authority that must sign. You are dealing with a property that is jointly owned. Let's say a couple, they are the one, they own a property. Let's say Mr. A Ada, Mr. B Ada, they are the owner of a parcel of land and they want to sell it. Who then becomes the appropriate person of authority to sign? The two, because the property is jointly owned. So these are the, concluding part is very simple, but these are the tricky areas that you must know, so that you will not just say, I was told you to have the concluding part. You have to calm down. It is a company. Who are the people to sign? It is a joint property. Who are the people to sign? Some people make the mistake of writing Mr. and Mrs. B Ada. No, you have to write the names of the party separately. Now, I've done this in the main tutorial video. And I told you, I've made earlier reference to this, that there is a PDF. What I've done in that PDF is to, when you say you want to dissect something, what I've done is exhaustively written. How do you identify parties? How do you draft? How do you all the questions I've already, when you say you've gone ahead to say this is what these students may likely face that may confuse them. So I've gone ahead, answer those questions, then so that when you are done with the main tutorial video, you watch this video, you can go through the documents and know how to properly identify the parties, right? And then draft the execution clause for each of the party to reflect their legal status. Also, you must be able to analyze any given scenario to determine whether any of the parties are illiterate or blind. Now, I said that to say this because the scenario we are working with, Chief Adeola and Jumoke Kende, is a transaction between private individuals. When you are dealing with transactions between private individuals, you must be careful when reading your scenario to be sure that the examiner has not hinted you that one of the parties is an illiterate or blind. Because the moment one of the parties, let's say Chattels is blind or is an illiterate person, even though Chief is in front of his name, it's not automatic that is literate. But like I noted in the PDF, you are not the one to tell the examiner whether Chief Adeola is literate or illiterate. The examiner will supply the information as to whether Chief Adeola is literate or not, or illiterate. It's not you that will say, well, Chief Adeola and chiefs might be illiterate. No, the examiner will supply the information so that you know whether Chief Adeola is literate or illiterate. So when we get to that point in the draft, I will take you to how to draft. I'll teach you how to draft the execution clause for an illiterate individual. So let's look at how to draft the execution clause. Since we are working with a scenario, right? Chief Adeola is a private individual. Jumoke Kende is also a private individual. So let's just look at how to draft the execution clause for the private individual. So in witness of which the parties have executed this deed in the manner below, the day and year first above written. That's our testimonium. The next thing we can go ahead to is our execution clause. Don't forget, schedule is not compulsory and mandatory. So we move into our execution clause by writing it this way: signed, sealed, and delivered by the within named assigner. Signed, sealed, and delivered by the within named assigner. Now, of course, in recent times, it has been said, oh, you don't need to write seal, but it does not, is not any consequential if you put it there, right? Signed, sealed, and delivered by the within named assigner. So, you draw a straight line, and then you write the name of the word assigner as said in the word scenario. The scenario identifies Jumoke Kende as what? Assigner. So you have to be very careful. Don't just go and write any name. It's the name in the scenario you're supposed to what? Put there. Now, this is where the mistake now takes place. If you are not careful, just say, signed, sealed, and delivered by the name assigner dash Jumoke Kende, and then you leave it. What you have just done is zero. Then you are wondering, why is it zero? It's not hard to tell. You said signed, sealed, and delivered, but there's no signature. So you have to what? Sign it. Just what? Improvise. Then you get your full mark. Why is this very important? A document that ought to have been signed but was not signed is what? Is a worthless piece of paper. So you don't expect the examiner to say, this person wrote the draft, but the person did not sign. So that means the person, he has an idea. You have no idea. Nobody is going to sign for you. You say, Shebi, it's just to. There's no, it's just to. That's why you have to be very careful. Don't be in a hurry when you are drafting. So you ensure you what? You sign. So after you have written Jumoke Kende, now, what follows it is the attestation, which we are going to talk about, right? And the reason I wrote it here, of course, here too, you ensure you sign. Now, the reason I've written this way is because I'm going to show you how to draft for assignee. But I don't want to mislead you or give you the impression that once you are done writing, signed, sealed, and delivered by the way the assigner dash Jumoke Kende, that the next thing is to write signed, sealed, and delivered for the assignee. You have to know that once you write signed, sealed, and delivered by the within assigner, the next thing that has to follow it is the attestation for that assigner, followed by the signed, sealed, and delivered for the within named assignee. That is why I've structured it this way, because I know that you are writing. So you don't get misled or start asking questions that, okay, if I write signed and delivered, do I need to, where will I now put the attestation? So you follow this format. After you have written the attestation for the assigner, then you have to write and draft the execution clause for the other party, right? Which is also signed, sealed, and delivered by the within named assignee. And then you also put dash, then Chief Adiola Bai, right? In the presence of, and then you fill it, the occupation, signature, then the date. Of course, like I said, you sign this. You also ensure you sign this. So don't forget this issue of signature. It's very, very important. Very, very important. Very, extremely what? Important. So this is how to draft the execution clause. Signed, sealed, and delivered by the within named assignee. So what if it was a lease? It is the same thing. Signed and delivered by the within named lessor in the presence of, you get, signed and delivered by the within named lessee in the presence of. So it's the same format that you will also what? Follow. I know I already promised you that we're going to, don't forget the signatures are there. Ensure you include the signature, right? Don't forget I told you that we're going to look at how to draft for an illiterate, right? Or a blind individual. So when an illiterate, just like we already explained in the main tutorial video, when an illiterate is involved in a property law transaction and the illiterate needs to sign, you must include what is known as an illiterate jurat or a blind person jurat. Now the question to ask is, who is an illiterate? And I want you to listen carefully. An illiterate is any person that does not speak, understand, or write in the language in which a document has been prepared. So for example, an English speaking man can be an illiterate to a French document. So let's say, for example, I communicate in English, right? The other party I'm transacting with, maybe he speaks French. Then the document was written in French. I don't write in French. I don't speak French. I don't understand it. For the purpose of that transaction, I am an illiterate. And it is expected that he has to read that document. Somebody has to read that document to me, interpret it to me in the language I understand before I then append my signature. Why? If you enter into a transaction with an illiterate, the illiterate can enforce the document against you, but you cannot enforce the document against that illiterate. So let's just say that by way of assumption that Chief Adeola Gbayi, let's say that Chief Adeola Gbayi was represented to us in our scenario as someone who did not understand English language. In fact, the moment you see it in your scenario that this person does not understand English language, is to tell you that, see, oh, hey, this person is an illiterate because he does not understand. Or the examiner says, Chief Adeola Gbayi, who speaks only Igbo language, who speaks only Efik language, is already hinting you that this person does not understand English language. So when you are told to draft the execution clause, you must draft it in such a way that an illiterate person jurat is what? Included. So how do you draft the illiterate jurat? So let's say that it is Chief Adeola Gbayi that is the illiterate, and we are now told to draft the execution. Of course, for the purpose of draft, we've written the testimonium. The testimonium. So we'll write it as signed, sealed, and delivered by the within named assignee, right? And then you have your dash, right? And then you have your Chief Adeola Gbayi, right? But you are not just going to stop here. You will now include that jurat. Now this is how to write that jurat. It says, the content of this deed having been first read and interpreted to him in Yoruba language by me of dash, that is your address, and when she appeared to have what perfectly understood the same before affixing a signature and what thumbprint. So you can see that in a way it captures the whole essence of appending your signature. That before appending the signature, it is clear that Chief Adeola Gbayi does not speak English. It is clear that does not understand English, therefore is an illiterate. So now you are including this illiterate juror to show that, see, before Chief Adeola Gbayi affixed his signature or added his thumbprint, we actually read his documents and interpreted it to him. Now, who is supposed to now attest to this jurat is not the party drafting. It's not the assigner that will now be saying, I interpreted the document. No. It is best to do it before a judge, a notary public, right? Or a neutral third party. But it's best to do it before a notary public. It just saves you the stress, right? So before me, notary public, right? And of course, then you sign. And then also don't forget to what? Sign here, right? So, and of course, if it's in a real life scenario, the notary public has his own seal and stamp, and that stamp will contain his entire detail, his name, his address, his everything, right? So before me, notary public. So you can see that this is how to draft an illiterate jurat. Of course, you cannot have illiterate jurat for a company. It's not possible, right? It's not going to be possible, right? So the content of this deed having been first read and interpreted to her, depending on the gender, in Yoruba language. What if the scenario told you he can only understand Igbo language? It will be in Igbo language. By me, you state the name. That means this notary public will state his name. Of what is your address? It will state his address. And when she appeared to have what? Perfectly understood the same before she affixed that what? Signature and thumbprint. So this jurat must be present. The moment you omit it, like I said, the contract, you can't enforce it against the what? Illiterate person. So these are the important and the salient points you need to note under the execution clause. So we move on to the next clause, which is what? Attestation. Attestation. Now this is very simple and straightforward. When we're discussing the concept of attestation in the main tutorial video, we said that according to Black Law Dictionary, it's just you saying, I saw. I can provide evidence to the existence of this fact because I saw it when it was being what? Done, right? So what is the purpose of the attestation? like we mentioned in the main tutorial video, the attestation is bearing witness to the execution. It's saying that I saw the party for which I'm witnessing for, I saw him or her signing this document. So, what the attestation clause must now do is that it must ensure to contain the full names, address, and occupation and signature of the person witnessing. What is he witnessing? The execution, not the payment. Oh, it's not the payment of the amount, right? It is witnessing the execution of the deed. So, for each of the parties, and of course, you must have seen, an insight into how to draft it when we're talking about the execution clause. Just like we mentioned, attestation is not a mandatory feature in the deed of assignment, right? It's not a mandatory feature. Now, whether it will be mandatory in other examples of deed depends on the law regulating that deed. But for deed of assignment, it is not. Which again brings me to another precaution. When we tell you that attestation is not a mandatory feature, most times it's for the purpose of your MCQ, not for the purpose of your drafting. So if you are asked to draft the concluding part, it's not for you to say attestation clause is not an important feature in the deed of assignment. Therefore, what I will do is I'll draft testimonium, I'll draft execution, I'll not draft attestation because it's not compulsory. No, you have to draft the testimonium, draft the execution, draft the attestation. But if you are asked in an MCQ, is attestation a mandatory feature in the deed of assignment? You can say, you can pick no. But no when you are what? Drafting. Afterward, it does not bite if you what? Add it when you are what? Drafting. Why is it that attestation clause is not an important feature in the deed of assignment? Section 99 of the Evidence Act says, if the attesting witness denies or does not recollect the execution of the document, the execution can be proved by other what? Evidence. So what if the person denies it, my signature was forged? Then you can use other extrinsic evidence to prove that this document is what? Genuine and what? Authentic, right? But it is not a mandatory feature in a deed of assignment. Of course, the fact that there's an illiterate jurat already, that one already means that there will technically be compulsorily an attestation because the person is the one interpreting to this person and that. But generally, attestation clause is not a mandatory feature. And I've said this particular point in a way based on what you've read in your bar finals and all of that. It's only asked in the MCQ. I've not seen them ask it in the theory question. You are just told to draft and you should what? Draft. Note that a party cannot serve as an attesting witness to a deed. So Chief Adeola Gbayi cannot say, signed, sealed, and delivered by the within named assignee dash is signed Chief Adeola Gbayi in the presence of Chief Adeola Gbayi. No. A third party has to serve as what? Witness to that execution. So how then do you draft the attestation clause? You have drafted your testimonium, signed it and delivered by the within name assignee. Jumoke Kende. Don't forget the next thing, sign. Very important. Now, in the presence of, that is, I signed this document in the presence of name, address, occupation, signature. Then you can also write the date. And don't forget, especially when you get here again, don't get too excited that the question is simple. The question is simple. Ensure you sign. You must sign. Take the signature of a thing very seriously. Even if you are rushing in your draft, the moment you draw that line, sign on it. Right? Who can you use for your attestation? If you are not giving any name in the scenario, you can improvise. But if for any reason you are told who witnessed the execution, it is that name you should use, because you are not doing child's play when you're in the exam. It's an examination. So the moment the examiner gives you a fact telling you that so person witnessed the execution, don't go and put your own name or put your friend's name. It is the name in the scenario that the examiner has told you witnessed it and you should use. It's an examination. So it's not just going to be, after all, Shebi, I got the name, address. It might be the other one that the marking scheme what covers. Now, we're only saying this just because we have read through the past questions, right? So let's ensure we put that disclaimer. So, in the presence of name, address, occupation, signature, and date, and please ensure you sign. So that is all to the attestation clause, right? Everything about attestation, we already talked about it in the main tutorial video. Now, the final is what? Of course, this is the attestation clause for the other party, which is the assignee, right? And that is Chief Adeola by. And then, of course, you ensure you sign, and then in the presence of name, address, occupation, signature, and then you have your dates. And of course, ensure you also what sign here. So the next and the last clause is what is known as what franking. And this one is like the chief. I mean, there's really nothing to explain here. Why? Because it simply contains the breakdown of the information of the lawyer who prepared the deed of assignment, right? And that includes the full name of the solicitor, the name of the firm, the address, the email address, and signature, right? Which is just to say, okay, under the Legal Practitioner Act, a legal practitioner can be hired, right? Can be employed. The service of legal practitioner can be employed to draft deed of assignment. So the lawyer is supposed to include his details, right? That I was the one that was prepared this document. And so how do you do that? It's kind of similar to the way you also frank your civil litigation processes, right? All you need to do is also you draw your dash, right? Then you write your name, then your firm, then you have the address, then you have your phone number. Of course, this phone number is fictitious in case you dial it. And then you have your campus races. In case you want to write to us, you can address us through campusraces@gmail.com. Yes, it will go through campusraces@gmail.com. I'll get your message. So, what do? You also sign. Say anything that has to do with signature, just ensure you immediately you sign. So the whole essence of franking is just to disclose the identity of the legal practitioner that prepared the document. Okay, so this is all we have to say about deed of assignment. So we have looked at introductory part, operative part, miscellaneous part, concluding part, right? So this brings us to the end of our discussion on the draft series on deed of assignment. Once again, subscribe to our YouTube channel, like this video, share this video with your friends. I'll see you in the next lecture video. I remain your tutor, Ile Mobayo Aboyewa.